So Prince William just filed a formal legal challenge against Queen Camilla's own daughter, and he did it without warning his father, without telling Clarence House, and without a single press release explaining why. Laura Lopes, who has walked freely through the most private spaces of the British monarchy for nearly 2 decades, has now been officially named in a legal document as an unauthorized occupant of restricted royal ground. And here's the part that actually changes everything. The mechanism William used to do this cannot be reversed by the king, cannot be absorbed by a palace committee, and cannot be quietly made to disappear. It is already moving, and Charles only found out when it was too late to stop it. Before we get into all of it, make sure you're subscribed so you don't miss the updates as more of this comes out. There is genuinely a lot more to this story. Alright, let's start where the story actually begins, because what happened at Balmoral is not the beginning. It is the ending, and to understand why, we need to go back considerably further than most people covering this have bothered to look. So here is what actually happened on the morning of Wednesday, the 12th of February 2025, a document bearing the authorization of the Prince of Wales, signed, sealed, and filed directly with the offices of the Crown's senior legal counsel named Laura Lopes as an unauthorized occupant of restricted royal ground. Not a guest. Not a family member given informal permission by a sympathetic king. An unauthorized occupant. That is the exact legal classification written inside the document. And that document did not pass through a single internal palace channel before it arrived on that desk. Laura Lopes is not a random name. She is the daughter of Queen Camilla, the stepdaughter of the reigning king, a woman who has moved through the most private spaces of the British monarchy, its restricted estates, its intimate family occasions, its internal administrative circles, for the better part of 19 years, and she was given absolutely no warning that this was coming. No call from Kensington Palace, no letter bearing an official crest, no private secretary reaching out through any of the courtesy channels the palace maintains, precisely for delivering difficult information with a minimum of collateral damage. Nothing. The filing simply arrived, and the process it activated began moving immediately, on its own institutional timeline, without requiring anything further from the man who signed it. And here's the part that actually stops you cold when you understand it. From the moment the credential anomaly at Balmoral was formally confirmed inside William's private office, to the moment that filing landed on the desk of the Crown's senior legal counsel, fewer than 72 hours. In a system specifically designed to move slowly, to absorb conflict before it reaches anything resembling a legal instrument, to give everyone involved time to adjust and negotiate and reach a quiet arrangement. 72 hours is not a bureaucratic timeline. It is a prepared one. Those documents were ready long before anyone outside William's immediate legal team knew a decision had been made. Now, here's what makes this even more significant. Standard credential challenges involving private royal estates, even straightforward ones, even ones with clear and well-documented justification, normally pass through an internal palace arbitration process before they reach any external legal mechanism. That process exists for a reason. It is slow by design. It takes between 3 and 12 months in ordinary circumstances. It gives the institution time to handle things privately, quietly, without generating a paper trail that moves beyond the household. That process was not delayed. It was not deemed inappropriate by anyone in William's circle. It was bypassed entirely. And the bypassing was not an accident. Because the people who operate at that level of the palace do not make accidental decisions about documents of this magnitude. Think about what was skipped here. Every internal stage, every courtesy channel, every mechanism the system provides for absorbing exactly this kind of tension before it becomes permanent and public and impossible to quietly reverse. All of it gone. Skipped. Deliberately. That's not how family disagreements work inside the House of Windsor. That's how institutional eliminations work. And what William was actually protecting, the specific thing that made him move this fast, this quietly, and this completely without warning, goes considerably deeper than one name on one access list. And that is where this story gets genuinely uncomfortable for everyone at Clarence House. Now, here's what makes this even more significant, and I need you to actually understand this part, because it changes everything about why William moved the way he did. Balmoral is not a crown estate. It is not government property. It is not held in the name of the British state, administered by a public body, or subject to parliamentary oversight of any kind. It was purchased privately in 1852 with personal royal funds, not public money by Prince Albert for Queen Victoria. Private purchase. Personal funds. No government involvement. No parliamentary approval. No public process of any kind. And that single fact, from 173 years ago, is the entire reason Balmoral still sits, to this day, completely outside the reach of the state. What that means practically is this. Balmoral transfers directly from sovereign to sovereign through the private bloodline, not through any governmental mechanism, not through probate, not through any act of parliament. When William becomes king, that estate does not go through a public legal process. It comes directly to him, which means the access credentials attached to that property right now are, in a very specific and very real legal sense, his future inheritance, and an unauthorized name sitting on that access list is not an administrative inconvenience. It is an unauthorized claim on something that will belong to him, personally, directly, without any intermediary. And here's the thing you need to understand about the scale of what we're actually talking about. The Balmoral estate covers approximately 50,000 acres of Scottish Highland. Its current private insurance valuation sits at approximately £94 million. The annual cost of maintaining it runs into the millions, covered through a combination of the sovereign grant and personal royal income. This is not a country cottage with a complicated guest list. This is one of the most historically and legally significant private landholdings in Britain. And, for over 2 years into Charles's reign, a woman with no royal title, no official function within the crown, and no blood connection to the House of Windsor had been moving through it on credentials that were never formally renewed for the new reign. But honestly, and this is the part that I think gets lost when people focus on the legal mechanism, the financial number is not actually what William is protecting here. Like, £94 million matters, but that is not what made him move in 72 hours. Ask yourself this: what is the one private place the royal family has maintained, across every public crisis, every media siege, every internal collapse of the past 30 years? The one place they retreat to, regroup in, grieve in, and hold as genuinely separate from the performance of monarchy, the place where the late Queen spent her final weeks, the place where she died, the place that is, for this family, the closest thing to ground that actually belongs to them rather than to the institution they represent. And then ask yourself what it means to William that someone with no formal claim to it had been walking through those gates freely on paperwork that nobody had been asked to examine for 2 full years into his father's reign. That is not an administrative oversight he was correcting. That is a boundary he was enforcing. And the reason he enforced it the way he did, that goes considerably darker than most people following this have yet begun to understand. But to truly understand why William could do this without flinching, without pausing for a family conversation, without giving anyone the chance to redirect him into a quieter process, you have to go back to the final 18 months of Queen Elizabeth's reign. Because the late Queen was not a woman who left things to chance. And the closer she got to the end, the more precise and the more deliberate her private preparations became. In the spring of 2021, Queen Elizabeth personally commissioned what those familiar with it describe as a private estate management framework, an internal administrative document covering the governance of all private royal properties across a sovereign transition. This was not a publicly announced policy review. It was not a committee recommendation. It was a sealed document, prepared with the direct involvement of 2 senior palace solicitors, and finalized under her personal signature in January of 2022, 8 months before she died. Its specific contents have never been publicly disclosed, but according to people with knowledge of its scope, the framework contained explicit provisions governing the reauthorization of access credentials following a change of sovereign provisions, significantly more rigorous than anything in the previous administrative guidance. And it contained at least one clause that addressed, in direct and unambiguous language, the exact scenario of informal access arrangements made during a coronation transition period that had never gone through formal reauthorization. She saw it coming. She built the instrument, and she left it for William to find. Now, here's what makes that genuinely devastating when you sit with it. The Queen did not commission that framework in a vacuum. She commissioned it after watching, for nearly 20 years, how proximity to the crown informal, uncontested, gradually normalized proximity had been used to reshape the inner circle of her own family without a single formal decision ever being made. She had watched it happen with Camilla. She had watched the Parker Bowles circle move, carefully and patiently, from the outside edge of royal life toward its most private center. And she understood, with the particular clarity of someone who has seen a pattern repeat enough times, that the transition from her reign to Charles's would create the widest and most vulnerable administrative window in a generation. And honestly, if you know anything about what Diana went through in the final years of her marriage, about the specific way her access to royal spaces and royal functions was quietly, methodically reduced, while the people around her were extended courtesies, she was simultaneously being denied. Then you understand why William does not treat informal access arrangements as minor administrative questions. He watched what informal access, extended without formal authorization and withdrawn without formal acknowledgement, did to his mother. He was 15 years old when she died. He has never forgotten what proximity to the crown looks like when it is used as a weapon rather than a courtesy. The late queen understood that too, which is why she did not leave him a letter of intent or a private wish or a verbal instruction passed through a trusted aide. She left him a legal framework with a specific clause and a specific mechanism and a specific bypass provision that did not require anyone else's permission to activate. That is not a grandmother leaving comfort for a grieving grandson. That is a sovereign leaving ammunition for the heir she trusted to use it correctly. And the only question that remained from the moment that framework was sealed in January of 2022 was whether William would find it before the window it was designed to close had already been exploited beyond recovery. And this is the detail that stopped me cold when I first really looked at it, because the strategy was actually pretty clever. Like, genuinely clever. It was not aggressive. It was not loud. It did not announce itself as a strategy at all. And that is precisely what made it so difficult to challenge. If you were designing a plan to embed yourself permanently inside the inner administrative circle of a private royal estate, you would not do it the way people imagine these things are done. You would not make demands. You would not push for formal recognition. You would not do anything that generated a paper trail pointing directly back to an intention. You would be consistently present, consistently useful, consistently discreet, and you would let the paperwork take care of itself. You would let time and familiarity do the work that a formal request never could. And then you would wait for the one administrative window, the one moment of genuine institutional chaos that would allow an unauthorized arrangement to quietly cross the line from temporary to established. That window was the coronation transition. And Laura Lopes walked through it. Here is the specific shape of what happened. Laura held active Balmoral access credentials that had been originally issued during the later years of Queen Elizabeth's reign, attached to an interior design consultancy arrangement connected to the private residential quarters of the estate. The consultancy work was real. The access was legitimately granted for a specific and limited purpose. But when the administrative transition following the late Queen's death should have triggered a full credential review, when every informal arrangement across every private estate should have been submitted for formal reauthorization under the new reign, the documentation supporting Laura's continued access was not submitted. It was simply carried forward, without a reauthorization request, without a formal renewal, without a single authorizing signature being added, updated, or verified, just carried forward, quietly, into a new reign. The interior design arrangement that originally justified the credential was administered through a company called Quintrell Associates, registered in London, with a documented commercial relationship to Laura's personal professional network. The arrangement had a stated value of approximately £42,000 annually. It had not been formally renewed through any competitive review process since 2020. It had not been formally cancelled either. It existed in a specific category of administrative limbo, never formally extended, never formally closed, generating no paper trail that anyone in the household had been asked to examine. And here's the part that makes the whole thing genuinely audacious when you understand it. By the time William's audit team identified the anomaly in late 2024, those credentials had been active and unchallenged for over 2 years into Charles's reign. 2 full years without a reauthorization request. 2 full years without a formal challenge. 2 full years of a pattern that, in the specific administrative language of royal estate management, was quietly building the foundation for something uncomfortably close to established precedent. In institutional terms, and this is the part that people inside William's circle reportedly found most alarming, 2 years of unchallenged access is not nothing. It is the beginning of a claim. She was not asking for permission anymore. She was waiting for permission to become unnecessary. and she was one administrative renewal cycle away from getting there. Okay, so here is the part that actually changes everything. And I mean that in the specific sense that when you understand what William's team found inside that archive, the entire chain of events that preceded it looks completely different. The filing was not a reactive move. It was not William losing patience after 2 years of quiet frustration. It was the culmination of a process that the late Queen had already begun, a process she had sealed inside a document, locked inside a solicitor's archive in Edinburgh, and left there for the person she trusted most to find when the moment required it. William did not build the weapon. He inherited it. He just had to find it first. In October of 2024, a member of William's private legal team conducting what was logged internally as a routine audit of sealed administrative documents connected to the private estate governance framework located a copy of Queen Elizabeth's privately commissioned management framework inside a bought solicitor's archive at a firm on Queen Street in Edinburgh. The document had been sealed under private royal document protocols. It was not listed in any public inventory. It had not been referenced in any palace communications since the Queen's death. It had not been flagged to any member of the King's household during the coronation transition. It had simply been sitting there, intact, undisturbed, bearing her signature dated the 28th of January, 2022, 7 months before she died. The framework ran to 47 pages, but the relevant clause was precise, unambiguous, and almost shockingly specific to the exact situation William's audit had already uncovered at Balmoral. In plain English, it said this: any access credential attached to a private royal estate that had not been submitted for formal reauthorization within 180 days following a change of sovereign was to be considered automatically lapsed regardless of whether a formal revocation had ever been issued. Not suspended, not under review, lapsed. And the mechanism for formally challenging and removing a lapsed credential bypassed internal palace arbitration entirely, proceeding directly to the Crown's external legal review process. The late Queen had written the bypass herself. She had written it into a sealed document in January of 2022, 8 months before the coronation transition, created the exact administrative window that Laura's credential had persisted through without challenge. She saw it coming. She closed the door before it happened. And she made absolutely certain that the person she left the key for would not need anyone else's permission to use it. And honestly, when you sit with that for a moment, that is not passive estate administration. That is not a woman tidying up paperwork before the end. That is a sovereign who understood, with total and unsentimental clarity, what the transition to her son's reign was going to produce. Who understood which vulnerabilities would be exploited, in which direction, by which people, and who decided, very deliberately, to make sure her grandson had something to reach for when it arrived. William did not stumble onto a loophole. He found exactly what she left for him to find. And the moment that document was in his hands, the 72 hours that followed were not a reaction. They were an execution. He didn't make a speech. He didn't give an interview. He didn't call his father, text his stepmother, or instruct a private secretary to reach out to Clarence House with any kind of advance notice. On a Wednesday morning in February of 2025, William sat down, reviewed a document that his legal team had spent 3 months quietly preparing, and signed it. That was the entire visible event, a signature, and the consequence of that signature began moving through an institutional process that does not require his continued involvement to reach its conclusion. Now, some of you are probably asking whether William can actually do this, whether an heir to the throne can file a formal credential challenge against an estate owned by his father, naming his stepmother's daughter, without the king's knowledge or permission. And the answer is yes, completely, legally, and without any ambiguity whatsoever. Here is why. And here is why the specific way he did it matters just as much as the fact that he did it at all. Balmoral is private property. It transfers directly to William the moment he becomes king, not through government process, not through parliamentary approval, directly. As the formally designated heir to a privately held royal property, William possesses the legal standing to challenge access credentials attached to that property that were never properly reauthorized following a change of sovereign. And the late Queen's sealed framework, 47 pages, signed January 2022, sitting undisturbed in an Edinburgh archive, until William's team found it states with complete clarity that lapsed credentials can be formally challenged through the external legal process without internal arbitration. He had the framework. He had the standing. He did not need the king's permission. He did not need a vote taken by any palace committee. He did not need a single conversation with anyone at Clarence House before his signature went on that document. Nothing. No permission required. And here's the thing that actually makes this kind of brilliant when you think about it. The specific category of legal challenge William activated does not have a withdrawal mechanism once it enters the external review process. It cannot be recalled by a phone call from Clarence House. It cannot be absorbed into a private family conversation and quietly resolved there. It cannot be redirected into an internal committee review that moves slowly enough for the problem to be managed out of existence before it generates a permanent record. It moves forward on its own timeline. It generates its own paper trail. And it arrives at its own legally binding conclusion regardless of what anyone at Clarence House wants, regardless of what King Charles feels, and regardless of what Laura Lopes or her mother decide to say publicly in the weeks that follow. That is precisely why the bypass of internal arbitration was not an aggressive escalation. It was a structural necessity, because internal arbitration can be slowed. Internal arbitration can be redirected. Internal arbitration produces outcomes that remain inside the household manageable, deniable, reversible. The external process produces a legal record. And a legal record is the one thing that cannot be quietly unmade by the people who would most benefit from its disappearance. William did not lose his patience after 2 years of quiet frustration. He finished his preparation. He waited until every document was in place, every legal basis confirmed, every alternative pathway his opponents might use to slow him down already closed. And then he signed his name. And he let the process do the rest. And here is the thing: nobody announced anything. Nobody made a statement. No palace spokesperson appeared in front of a camera to explain what was happening or why. The royal family does not do that. What it does instead is far more efficient and far more devastating. It lets the choreography of a formal occasion do the communicating for them. And on the 14th of March 2025, at a Commonwealth reception held at Buckingham Palace, the choreography was unmistakable. Laura Lopes arrived at that reception having attended the same event in the same capacity for 7 consecutive years. She had stood in the formal receiving line at this occasion in 2021, 2022, 2023, and 2024, without incident, without challenge, and without any visible acknowledgement from the institution that her presence required any particular consideration. It had become, through sheer repetition, something that looked almost like belonging, almost like an arrangement that had been formally sanctioned rather than simply never challenged. She walked in on the 14th of March expecting the same thing she had experienced every previous time. She did not get it. As Laura approached the position in the receiving line she had occupied at every previous iteration of this event, Princess Anne, standing approximately 6 feet to her left, took one step, a single, visible, entirely deliberate step that physically closed the gap between Anne's position and the formal receiving line. One step to the left. No words. No eye contact. No scene of any kind. Just a step, held with the particular stillness of someone who had thought about exactly this moment and was not remotely uncertain about executing it. Laura was left standing in the adjacent space, the space used, in the specific language of royal ceremonial protocol, for family-adjacent guests rather than principals. To a first-time viewer of the clip, it looks almost like nothing. A minor positional adjustment in a formal room, barely worth a second glance. But here's the thing. In the specific spatial language of royal receiving lines where every position carries institutional meaning, where the difference between standing inside the line and standing adjacent to it communicates an entire classification, that single step was not a minor adjustment. It was a verdict, public, visible, and delivered in a format that left absolutely no room for alternative interpretation. The clip was watched 11 million times in the 48 hours that followed. It was slowed down, replayed, analyzed frame by people who wanted to be completely certain they had understood what they were seeing. They had. And here is why Anne specifically matters as the instrument of this moment. Princess Anne does not make accidental social gestures at formal royal occasions. She is the most institutionally precise member of the working royal family, a woman whose relationship to ceremonial protocol is so deeply understood by everyone around her that a deliberate deviation from it carries more institutional weight than a press release from any palace communications office. When Anne moves, it is because she has decided to move. When she chooses to communicate something through physical positioning rather than language, the message is not ambiguous. It is not emotional. It is not open to reframing by a sympathetic spokesperson or a carefully managed briefing. It is institutional. It is final. And it is the kind of signal that cannot be walked back the morning after. The power shift was no longer just a legal document sitting inside an external review process. It was now visible, in public, on camera, watched by 11 million people who understood exactly what one step to the left meant, and Camilla's team went into full damage control mode. Within 48 hours of the Anne clip going viral, there was this carefully managed wave of messaging coming out of the Queen Consort's communications circle. Nothing official, nothing attributable to a named source, but consistent enough in its framing and precise enough in its timing that the coordination was not difficult to identify. The narrative being pushed through sympathetic royal correspondence and carefully cultivated media contacts followed a specific and deliberate line. Laura Lopes had been unaware of the credential situation. The access arrangement had been a matter of administrative confusion rather than deliberate impropriety, and the entire matter was being resolved privately and constructively through internal palace channels. 3 separate briefings, same language, same framing, launched within a 72-hour window of each other. And here is where the strategy fell apart, because the legal filing that William had activated does not have an internal palace channel. It is not subject to private resolution. It is an external legal process with its own institutional timeline and its own public record. And the claim that it was being resolved privately and constructively through internal channels was, in a very straightforward factual sense, simply not true. Every royal correspondent who received that briefing and then looked at the actual legal record discovered, within minutes, that the narrative being offered to them did not match the documented institutional reality. The process was not being resolved privately. It was moving forward, on its own timeline, generating its own paper trail, completely beyond the reach of any communications office, regardless of how carefully its messaging had been coordinated. And then the specific, concrete evidence of collapse began arriving. The Quintrell Associates consultancy arrangement, the commercial relationship that had provided the original justification for Laura's Balmoral credential, was quietly dissolved in late March of 2025. The company's filing at Companies House shows a cessation of trading recorded on the 22nd of March. No public announcement, no explanation offered through any channel. The legal challenge had been filed in February. The company that had been used, even nominally, to justify the access arrangement stopped operating 5 weeks later. That is not a coincidence. That is someone removing the scaffolding from a structure that had already collapsed. A forthcoming private dinner at Windsor, scheduled for the second weekend of April, appearing on internal planning documents as an occasion involving the wider extended family circle, was quietly revised. Laura Lopes' name did not appear on the updated guest list. No explanation was offered to the people who had received the original invitation. And then there was a phone call. 3 of them, actually. Made by Camilla's private secretary on the afternoon of the 9th of May. The same afternoon, the final legal document was confirmed inside William's office. The first 2 calls were answered. The third was to William's office. It went to voicemail. No message was left. She had spent nearly 2 decades outmaneuvering the informal social architecture of the royal family, with a patience and a precision that most people around her genuinely admired, even when they were uncomfortable with where it was leading. But William had never been informal about any of this. Not once. Not for a single day of the 3 years he had been quietly building toward this moment. And that is the one thing she had fundamentally, catastrophically miscalculated. And then, on the 9th of May, 2025, on an entirely ordinary Friday, with no formal engagement scheduled and no media presence positioned outside any royal residence, William signed the final administrative document that completed the credential review process. No statement was issued. No spokesperson appeared. No royal correspondent received a briefing explaining what had happened or when. The document was signed, the process concluded, and William returned to his afternoon schedule as though nothing of particular consequence had just occurred. Which is, of course, exactly the point, because the most consequential moves inside this institution have always looked, from the outside, like nothing at all. The legal challenge was resolved. The lapsed credential was formally closed under the provisions of the late Queen's sealed estate management framework. Laura Lopes' access to Balmoral, and to the secondary private estate access arrangements that had been connected to the same administrative review was permanently revoked. Not suspended pending further review, not reduced and restructured into something more limited, permanently revoked. The word in the document is not ambiguous, neither is its consequence. 3 days later, on Monday, the 12th of May, William, Catherine, and their 3 children arrived at Balmoral for a private family stay. The estate gate was opened by the groundskeeping staff. The vehicle access roster that had been revised following the February filing was in place. The names on it had not changed. The family walked through the gate. The gate closed behind them. And that was it. That was the whole thing. Dawn, no drama. No scene. No moment designed for a camera or a headline or a carefully timed palace statement positioning the outcome in the most favorable possible light. Just a family arriving at an estate that has belonged to the private royal bloodline for 173 years, on credentials that had been properly authorized, reviewed, and confirmed, exactly as the late Queen's framework required. Exactly as William had spent 3 years quietly, methodically preparing to ensure. Now, here is the part that nobody inside the palace will describe in detail, but that people close to this situation have referenced carefully and consistently. On the afternoon of the 9th of May, the same afternoon the final document was signed inside William's office. Camilla cancelled a scheduled appearance at a private charitable engagement without public explanation. The cancellation was attributed in palace communications to a scheduling adjustment. She spent the remainder of that day in private at Clarence House. No official acknowledgement was made of what had been concluded that afternoon. No statement was released. No coordinated messaging emerged through the sympathetic media contacts that had been so active in the weeks following the Anne clip. Just silence. The specific contained silence of someone who has understood, finally and completely, that the thing they were hoping might still be redirectable has reached its conclusion. And here is what that silence actually means. It means the damage control phase is over. It means the negotiation phase, the quiet, informal, entirely deniable series of communications through which institutions like this one normally find their way to arrangements that allow everyone to preserve some version of dignity never happened. Because William did not leave a negotiation open. He did not file a challenge and then wait to see what kind of private arrangement might emerge from the pressure it created. He filed. He waited for the process to conclude. He signed the final document, and then he took his family to Balmoral. When you step back and look at the entire chain of events from the moment William's audit team found that credential anomaly in a legacy access document, through the October discovery of the late Queen's sealed framework, through the February filing, through Anne's single step at the Commonwealth reception, through the dissolution of Quintrell Associates and the closed gate at Balmoral on the 12th of May, what you actually see is not a family dispute that escalated beyond anyone's intention or control. What you see is a transfer of power being conducted entirely on William's terms, at William's pace, using instruments that were legally his to use, in a silence so complete and so deliberate that the people being displaced did not understand what was happening until it was already irreversible. And here is what that actually means. William did not gain access to a Scottish estate. He gained something considerably more significant than that. He gained proof of concept. He demonstrated, across a sequence of institutional moves that produced 0 successful countermeasures and 0 public pushback that landed, that he can act unilaterally on matters touching his future inheritance, bypassing internal arbitration, bypassing Clarence House, bypassing the palace communications machine entirely, and that the legal framework to support those actions is already in place, already tested, already confirmed as operational under real conditions against real opposition inside the most scrutinized family in the world. The sealed framework Queen Elizabeth left him was not a document. It was a template, and the question of what else it covers, which other arrangements, which other credentials, which other informal access patterns have accumulated across the transitional years of Charles's reign without proper reauthorization, is precisely the question making the people responsible for those arrangements deeply uncomfortable right now. And then there is the part of this story that goes all the way back to a Paris tunnel in 1997. Because William did not arrive at this moment without a history. He watched, as a child, what informal access to the crown looked like when it was extended without formal authorization and withdrawn without formal acknowledgement. He watched proximity being used as a weapon. He watched his mother navigating a world in which belonging and permission had been allowed to become so thoroughly confused that by the time the distinction was enforced, the enforcement felt like an act of cruelty rather than an act of institutional clarity. He has never forgotten what that looked like, and he has spent the years since he acquired the power to act on that memory, making absolutely certain it does not happen again. Not on his estates, not on his watch, not on credentials that were never properly his father's to extend in the first place. The late Queen understood all of this, which is why she did not leave him a letter of comfort or a private wish or a verbal instruction passed through a trusted aide. She left him a legal framework with a bypass provision and a specific clause, and a signature dated January of 2022. She trusted him to find it. She trusted him to use it correctly. And she trusted him to understand, without being told, that the moment to use it would arrive and that when it did, he would need to move without hesitation, and without sentiment, and without leaving a single door open behind him. He found it. He used it. He closed every door. The boy who walked behind his mother's coffin at 15 years old did not become the most powerful man in Britain by accident. He became it by preparation, and he is just getting started.